All right, I think it's time to go ahead and get started. Well, thank you everyone for joining us today. I'm here today with my colleague Ashley Watson, and we're going to present on an issue that we literally could not have picked a more timely date to do this, and truly is all coincidental. But given the passage of marijuana legalization in Ohio just last evening, I think it's a great time to cover the topic of marijuana in the workplace. So I'll be presenting today from the side of employer prohibitions of marijuana, what you can do, what you can't do. And then I think Ashley is going to really present on the licensure implications on professional licensure with use of marijuana. To get started, I guess just quick word about myself. My name is Bryan Meek. I am the partner and co-chair of the Employment and Labor Law Group here at BMD, and I'll let Ashley introduce herself.
Thank you. I'm Ashley Watson. I'm a partner in our BMD Columbus office, and I do healthcare regulatory compliance and policy. I'm looking forward to talking to you today.
So before we get started, we do want to give a quick disclaimer. Although Ashley and I are lawyers, we may not necessarily be your lawyers yet. There may be some of you on the call who are, but for purposes of this presentation, this is not legal advice. So if you have any follow-up questions after today's presentation, definitely let Ashley or I know, and we could certainly set up a call outside of this meeting today to discuss your questions. However, for purposes of today's presentation, we really kind of want this to be interactive, given the passage of the statute last night. So any general questions you may have about the statute and maybe where Ashley and I see things going, feel free to put those in the question box throughout the presentation. We originally slated today's presentation to be for 30 minutes. And, I think actually I will be able to present on our topic in 30 minutes or less, but we want to allow as much time to answer all of your questions that you may have. So we're going to go ahead and extend today's presentation out to an hour to the extent there's still questions to answer. So don't hesitate to leave any questions you may have in that chat box or the question box throughout the presentation. So before we get started, or actually, let's go ahead and get started on the topic. And as a general overview, we're primarily going to discuss today the marijuana laws in Ohio. However, many of these concepts we're going to discuss really will translate as well into other states, particularly those that have medical and or recreational legalization. So if you have specific questions about other states, just let us know and we can speak with you about that. But like I said, today we're just going to kind of use the rules in Ohio to help guide our discussion. So to start, what is the current status of marijuana legalization in Ohio? I had to change this presentation this morning, but it is now legal recreationally effective December 7th, 2023. Obviously, the state of Ohio overwhelmingly approved issue 2 last night, which creates recreational legalization for users 21 years of age and older. Although we were talking to some of our experts this morning, although we expect it'll be another 6 to 9 months before recreational stores actually open to the public in Ohio, to the extent people are able to obtain marijuana through other means, they're going to be able to legally possess that beginning on December 7th. As well as the recreational legalization, Ohio also has medical recreational legalization, which has been on the books since 2016. Under this program, users with qualifying medical conditions, and there's a pretty lengthy list of what conditions qualify, can use and purchase medical marijuana through a controlled retailer. As of right now, those retail shops are up and running. I know there is a very large number of Ohioans who have their medical marijuana card for use with their underlying medical condition or disability. So it's pretty common, pretty widely used program, and some of your employees may even have their medical card. So in terms of regulations, under Ohio law, employers are not required to permit or accommodate an employee's use or possession of medical marijuana. And what that really means is, despite the passage of issue 2 yesterday, despite the existence of medical marijuana in Ohio, employers still have great freedom in determining whether they're going to allow employees to use marijuana, obviously during the workday, but then even after the workday at home. If employers are free to create a policy that says no marijuana use at all, nothing's changing for us. You can't use marijuana during the workday, you can't use it when you get home. And it doesn't matter whether you have a medical card or not. That's irrelevant under Ohio law. Employers can make that decision. Employers could also make the decision, and we expect this is where many of them will likely end up going eventually, but to allow obviously usage of marijuana at home, similar to the use of alcohol. But obviously, they're not going to allow employees to use marijuana during the work hours or come to work under the influence of marijuana, similar to how they would treat alcohol. But where things stand right now in Ohio, and this will not change come December 7th, employers can refuse to hire, you can discharge, you can discipline any individual because they used marijuana either medically or recreationally. So as I had indicated, under current Ohio law, it's irrelevant whether your employees have a medical marijuana card or not. That does not protect them from adverse employment decisions, including, failure to hire or anything like that, as a result of their use. And just quick recap, as I'd indicated, employers I guess let's talk for a moment on medical marijuana in terms of what you may also make the decision to do. And, employers could make the decision theoretically starting on December 7th that no one's allowed to use recreational marijuana. You could say, we don't care whether you use it at home or during the day, you're not using it at all, right? So no recreational. But we will continue to allow those with a medical card to receive an accommodation, under the ADA or similar Ohio statute to allow them to use medical marijuana at home. I don't know how many employers are really going to draw that line on that use, but I assume there will be some that do that. But that is something that is still Ohio employers are still able to do. No matter what you decide, what option you're going to decide to use going forward, you need to create a detailed work policy on what you plan to do for enforcement. And we already have our clients calling us, wanting to update their policies, wanting to create new policies as a result of the legalization last night. So if it's been a while since you've updated or reviewed your drug place policy, definitely get in contact with us or your other trusted employment advisor on how best to make those changes and to really work with how you want to implement marijuana use for your workplace. One question I often get is, and I think we're gonna just go ahead and get to that right now. One question I often get is under the ADA, and Ohio has a similar statute, you're required as an employer to accommodate an employee's disability. And medical marijuana especially is prescribed in many instances for the treatment of a disability. Therefore, similar to other medication, it comes to be that, hey, the use of medical marijuana could be an accommodation under the ADA. Don't I have to accommodate it? The answer to that is outright no. Because marijuana remains illegal at the federal level, its use as an accommodation cannot actually legally be considered under the ADA, and courts are very clear that employers do not have to allow the use of marijuana as an accommodation under the ADA. Similar to Ohio is a very similar accommodation statute as well. And based on the language, I actually have it right here, but based on the language of the new statute that was just passed last night, employers are still not required to accommodate the use of even medical marijuana for employees with disabilities. So again, employers really retain great freedom in enacting the policies they wish to enact. As I had indicated, and this is going to become important for our next topic we're going to shift into, but under the Federal Controlled Substances Act, marijuana is still considered a Schedule I drug, which is the most highly regulated. It's up there, obviously, with heroin and those other major drugs. So That's for all aspects. I will say now we're going to expect that the Biden administration will ultimately remove marijuana from a Schedule I classification, likely sometime in the next 12 months. However, it's still on that classification. Nothing is formally changed yet. But why does this matter? The reason this matters is because some of you on the phone may have what's called a federal contract, or you're considered a federal contractor. As a federal contractor, most employers with those contracts have requirements that say they must maintain a drug-free workplace, and that's interpreted at the federal level. So that means you still would be required to outlaw the use of marijuana even outside of work, and you have to undergo drug testing. It's similar for any employers on the phone that may have ODOT licenses or federal Department of Transportation licenses. You're still going to be required to go through that testing as they require, including marijuana testing. So if you are a federal contractor, just to quickly sum that up, but if you're a federal contractor, you're going to want to ensure that you're speaking with your attorney about your requirements, if any, to implement a drug-free workplace, and whether marijuana will be exempt from that testing, either now or in the future, to understand what your boundaries may be. One question we often get here, and Ashley may touch on this a little bit as well, is, are healthcare providers that have Medicare or Medicaid contracts considered federal contractors? We've taken the position, and there's been a lot of secondary support for this as well, that simply having a credentialing agreement with Medicare or Medicaid, or they're implementing contractors, does not necessarily make you a federal contractor for purposes of the Drug-Free Workplace Act. However, if you have another type of federal contract or grant that extends beyond that simple credentialing to receive reimbursement from Medicare, Medicaid, then you may be required to implement those drug-free workplace requirements. Again, that should really be spelled out in your contract that your attorney can certainly help you walk through and review. Similar, let's talk about real quick the Ohio Drug-Free Workplace Program. Ohio, some of you may be aware, but Ohio, through its Bureau of Workers' Compensation, actually has a program that employers can subscribe to receive discounts and rebates on their workers' compensation premiums. A lot of construction entities really participate in this just to help ensure they keep their premiums low. But under this program, similar to the federal level, employers, if they participate, and again, participation is voluntary, but if they participate, they're also required to implement a drug-free workplace program that includes testing, and then obviously discipline and potentially discharge for use of marijuana or other drugs. The question we're getting already this morning is whether they will have to, if they participate in this program through Ohio, the state level, whether they will have to either withdraw from that program or continue to discipline for their recreational use of marijuana. The answer is, at this time, the answer is yes. They would either have to withdraw from the program or discipline and discharge for the use of marijuana to stay compliant with that program. However, it is possible, and the statute recognizes that the Bureau may change the classification of marijuana for participation in this program. They may remove the requirement to test for marijuana from this program, but as of right now, they have not made that change, and it's not clear whether or not they're going to make that change. The Bureau falls really under the purview of the governor and through the Attorney General's office. And as we're actually talking before we joined this call today, both of those offices are still staunchly against the recreational legalization of marijuana. So it's not clear whether they would actually amend these programs to take marijuana outside their purview, but it's something we may eventually see.
Hey, Brian, we have a question.
Yep.
This is actually about the federal grant slide, but I think it's a good one. So the question asker says that if the federal grant is only one portion of our business, can we just have that policy, the drug-free policy, for those employees under that contract, or does it need to be every employee in the company?
That's actually a great question. So typical lawyer answer here, but it depends. And the reason I say it depends is it depends on the grant or the program that the contract is under. A lot of contracts, so I will say, and a lot of grants will just require regulations on the employees that are actually performing work under that contract or for that grant. So the answer to your question would then be, yes, you could exempt those employees who are not under that grant or performing services under that contract, as long as your contract allows for that exception. And to the extent it does, you could really develop two policies that would be permitted that says, hey, if you're working under this contract or under this grant, you're not allowed to use marijuana recreationally or medically. And then on the other side, if you're not working under that grant or contract, we will not be testing for, and you will not be disciplined or discharged for the use of marijuana.
That is a really good question. I've got one more question now about the Ohio Drug-Free Workplace Program. Yep. So under Ohio Drug-Free Workplace, can an employer make expectations for medical marijuana and non-safety sensitive positions?
Yep. As of right now, again, the answer to that question is technically no. You can't make an exception for medical under that program. We were really hoping that as we saw the medical program really get off the ground, that the Bureau would change their stance on the use of medical. We still have not seen that. We're hoping that that does change, maybe here in the next couple of months with the passage of recreational. But I guess in response to that, just stay tuned. We can. And we can also talk offline about maybe some options that might be available, but stay tuned for potential amendments to that. That's just, we talked about that. So let's talk about, we spoke for a moment on, employers are now at the point where they're going to need to decide, which route you're going to take. And I will say this. The statute now has language that says if an employer if an employer is going to make an adverse employment decision for the use of marijuana, say they drug test either randomly or to start employment, and a person tests positive, and they're going to terminate or refuse to hire that employee because of that positive test for marijuana, that's going to be, that needs to be spelled out in a policy. You need to reduce what you're going to do to a written policy that's communicated to your employees. The reason is, to the extent you make decisions that are adverse to an employee regarding marijuana and it's not reduced to a written policy, that employee will not be considered to be discharged with cause, meaning you would be on the hook for all those unemployment benefits. They're not going to be able to sue you for discrimination or anything. That the statute's clear on that. But as we read the statute here today, and as we've interpreted it this morning, if you're going to discharge someone for using marijuana and it's not in a policy, then they are going to be able to receive unemployment benefits, and that would ultimately impact your unemployment tax rate. So again, it's important that, as December 7th approaches, that, you get with your attorney to, discuss what options are best for you when it comes to, implementing what you want to see done at your workplace for marijuana usage. I think I saw 2 new questions come in. Yep.
Yeah. So the first one I think goes along with the policy that you were discussing. How is the influence of marijuana measured in a drug test, since it could have been used on days prior? Kind of how do you work that into your policies?
Sure. So that is an amazing question that I think is fairly complex. I know, scientists are currently working on a program or some devices to test the quantity or levels of marijuana in the system, especially for purposes of driving and active intoxication. But I do know that a lot of drug testing contractors that we've spoken with for our employer clients, they do have now a way to measure the level of THC that's currently in the system, and then they would be able to provide guidance to you, based on the employee's age, weight, things like that, to maybe come up with a rough estimate as to when that last usage likely would have occurred based on the level present in the system. So again, if you have someone who is applying for a job, but they end up testing positive for a pretty minute amount of THC, it could have been that they used it 30 days ago or 20 days ago, and even before they contemplated applying for your employment, and you might allow them to still come on. Conversely, if you suspect that someone may be actively using marijuana at work and you send them for an immediate, reasonable suspicion drug test, then, they would hopefully be able to use those testings to determine, it does appear based on these THC levels that they're, under the active influence of marijuana, or no, hey, it's likely that marijuana usage occurred, last night or the day before or outside of work hours. So that's a very complex way of saying you'll have to work with your drug testing provider to really determine, how to interpret the results based on the age and weight of the employee. And then I see a second question just came in. Should we be adding anything into our applications regarding that as well? If you're going to test applicants for marijuana and continue to do so, it might be a best practice to include that in your application, in addition to obviously having a written policy as well. And the reason is, if you're going to test for marijuana and make decisions on hiring based on whether they test positive or not, once recreational goes into effect and there's now going to be wide usage of marijuana, you're going to want to remove those applicants from your pool as quickly as possible. That way you're not wasting time going through the hiring process only to ultimately find that, hey, they tested positive and you're not going to move forward with them anymore. So it's really going to be a time saver for you, to have that, to have that caveat in your application that says you would test and make decisions based on marijuana usage. I think that, so I guess just kind of in sum here, employers have discretion with regards to allowing both recreational and medical marijuana usage. But again, under the federal contracts, we may need to be speaking with you about how to interpret those contracts and your requirements to implement drug-free workplaces. So just definitely get with us if you have any questions, and then to also help revise or implement any additional policies you're going to need to make ahead of the December 7th implementation. And now I think I'm going to shift it over to Ashley.
Yeah, thank you. So I just have a couple of slides that if you are a healthcare provider of any sort, then these are things that you should consider as well. We know that, especially now, marijuana is going to become kind of a widely openly used substance, sort of like alcohol. We kind of like to think of now, you had to be over 21 to drink alcohol. We know that it has inhibiting kind of results, and marijuana can be the same way. So if you are an employer of licensed professionals, and I'm a healthcare attorney, so I talk about healthcare professionals generally speaking, but this applies to actually anyone who is licensed in the state of Ohio. If you're an employer of someone who is a licensed provider that has to answer to a board of some sort, then that board is going to have some sort of power to discipline your employee based on essentially operating under the influence if it turns out that their use of marijuana is impacting their performance. So you need to be considering when you're drafting your policies, if you employ any licensed individuals, that you're kind of looking at what those boards are going to be looking at. And we'll talk about what some of the boards have said so far. Not a lot of boards have come out with official statements necessarily, but I imagine maybe they will start to. But the major takeaway is, if your employees are coming into work and they are very clearly inebriated, high, under the influence of something, then that could subject them to discipline through their professional licensing boards, and that could mean that they would be taken away from their jobs because they might lose their license. So these are things that you need to think about if you're employing any sort of licensed individuals. Can you switch to the next slide, please?
Yep, great. There we go.
Perfect. So the Ohio Board of Medicine and the Board of Nursing, kind of just as examples, they regulate a huge amount of healthcare licenses, of course, but they don't give us any clear guidance on the use of medical marijuana or marijuana recreationally. Ohio state law provides that physicians are not subject to criminal prosecution and are immune from civil liability for recommending marijuana. when medical marijuana and those regulations were passed, that was something that Ohio made sure of to make sure that physicians, even though marijuana is still federally illegal, can recommend medical marijuana in the state. But physicians can still be disciplined by the medical board for performing medical services in an impaired state such that the physician is not able to practice according to acceptable and prevailing standards of care because of habitual or excessive use or abuse of drugs, alcohol, or other substances. So again, kind of think of the legalization of marijuana as treating it the same way that you would treat impairment because of alcohol abuse or something like that. Also, the Ohio Board of Nursing is authorized to discipline licensees for the impairment of the ability to practice according to acceptable and prevailing standards, just like the Board of Medicine. So any licensed individuals that you have, just make sure that they are aware that even though they technically can use marijuana recreationally starting December 7th, that doesn't mean that they can use it all the time or that they can use it in the workplace or that they can use it when they're performing their professional duties. They need to make sure that they are still treating their employment in a serious manner and that they're treating patients, especially in a responsible and professional way. The boards are kind of leaving it to employers to establish individual policies. So I doubt that a board is going to come out and say, like, you physicians cannot use recreational marijuana. They're never going to come out and say something like that. They're just going to say, what is your employer's policies? What are your facility policies? You need to follow those and make sure that you're treating patients and you're not impaired doing that. So just follow all of that guidance that Bryan has already talked about. Make sure you're establishing a policy about the use of marijuana. Make sure you're enforcing that policy amongst all of your employees. And you will probably have to start reporting, you may have to start reporting more individuals who are working impaired. And I kind of foresee perhaps some situations where patients might come in and then report to the board that their provider smells a little bit funky or kind of is acting a little bit strange. We may see some situations where professional boards are starting to have to do some investigations because people are like, well, I'm really worried about my provider using marijuana and they were acting kind of weird today, so I think they were high, so I'm going to report them just in case. I don't know how far that will go, but I wouldn't be surprised if we see a little bit of that. So just make sure you're clear with your employees. If you are impaired in any sort of way, do not come to work today, just like with any other sort of substance, and make sure that you're acting professionally at all times. Next slide, please. So there were actually some really good best practices that came out from the Ohio Counselor, Social Worker, and Marriage and Family Therapist Board back in 2018 when medical marijuana was being discussed. So this is the board that governs social workers, professional clinical counselors, marriage therapists, etc. So their takeaways were what we've already said. The use of medical marijuana by patients and recreational marijuana and professionals should be treated like the use or abuse of any other illegal or controlled substance. And there are no special protections for persons prescribed medical marijuana or employers, and employers are allowed to maintain drug-free workplaces even after December 7th, like Bryan said. So those who are under the influence of marijuana can be terminated if it's appropriate, if the use poses a danger in the workplace, which is similar to all other substances. So this board said counselors, but it could apply to any other professionals, can ethically use legal substances as long as they do not perform clinical duties under the influence. So each professional, and you should be requiring this of your employees who are professionals, licensed professionals, should evaluate their own use to ensure that the use does not impair their ability to function. So this could be anything from seeing clients while they're hungover to maybe prolonged impacts of marijuana use. And they are able to use the substances responsibly. So for example, a professional licensee can be punished by their board if they are driving under the influence, depending on the board's rules. So make sure that you're following those laws and you kind of keep your staff up to what those are in Ohio. And if professionals do choose to use legalized marijuana, they need to be aware of how long the effects last. So that was one of the questions that one of our attendees asked, but it's a really good one. If you are a provider and you use some recreational marijuana on the weekend, how long is that going to impact your cognitive abilities to treat your patients? Or is that going to have any sort of effect on you the next day? So you need to know those things before you use, and as an employer, kind of, you can set some expectations with your employees. You can put it in your policies if you want, but just let your employees know exactly what your policies are and what you expect of them and what professional activities look like. And then also a final note is to check your malpractice insurance. Make sure that it covers instances when providers are under the influence of legal but controlled substances, or kind of see what your malpractice insurance says about that. And if you employ physicians that want to recommend medical marijuana still, is that something your insurance covers? A lot of times it does not, because marijuana is still federally an illegal substance. And then finally also, if the federal government moves marijuana from a Schedule I substance to a different schedule substance, we will update you on all of the impacts that will have across the healthcare industry, but it will be very wide ranging, and it will be pretty huge for who can prescribe medical marijuana and how it can be used in a treatment context. So that's definitely something to keep paying attention to as we move forward.
I think, let me just go here. Yep. I think that's it for our formal presentation. If there's any other questions, about, the healthcare implications as Ashley presented on, or, obviously the impact on federal contracts, or how best to go about, changing or implementing, policies, that you're now going to need to implement, let us know in the question and answers box. Otherwise, you can contact, Ashley or our information's on the screen now. You can contact us after the presentation as well.
Thanks everybody for attending today.
Yeah, absolutely. Thank you.